Our last section on the sale of goods and leases is going to be products liability or warranties. We're going to talk mostly about warranties. So when a seller is liable for their products is what we're going to be discussing next. I want to remind you there is a sheet on Moodle, the handout on warranties, where I break all these rules down and have additional examples. And there's another worksheet with examples that will be in a separate video. I will mention in this video when those will be applicable for review. So buyers buying goods expect to get something, right? They expect to get the tangible object itself, and beyond that, to be blessed with the title to the property. But also there's other things to recognize, right? There's a whole host of other expectations a buyer has when they buy a product. We assume that it's not some mysterious thing that's hidden in a box. He or she is making the purchase because of what the thing is, or at least because of what the buyer believes the thing is, what it's made out of, what it can do, etc. The buyer wants the thing itself, but beyond that, wants it for its qualities that he or she understands that it has, right? If it does not live up to these expectations, the goods are not what the buyer presumed them to be. He or she will naturally expect to have some sort of right against the seller. If such rights are available, it's because he or she has, as the buyer, received some certain warranty, some warranty of quality. That's not a legal term. That's just what I'm going to describe it as right now. Certain warranties of quality along with the delivery of and a title to the goods. So the idea of the law of warranty is to determine what it is the seller has, in essence, agreed to sell. I don't want to delve into the history of warranties. I believe that there's a brief discussion in the book. But it does stem from the early English system in the 1600s, i.e. the common law, that buyers were afforded certain protections. But as time went on, that's extinct from the common law, and it's pretty much developed in a scheme. The warranties are developed in a scheme under Article 2. So, warranties. What's a warranty? It's an assurance by one party of the existence of a fact of which the other party can rely. We have three types of warranties. We have warranty of title, we have express warranties, we have implied warranties, and each one of them breaks down into their individual types of warranties. Now, there is a handout you might want to grab if you don't have it already. It's called a title. What that is a title of a vehicle. So we're going to kind of make reference to that when we're talking about title. So you might want to have that here. So the title. We have warranty of title, and it arises automatically in sales contracts. And I'm going to point out, not in leases. We're not dealing with titles and leases. Why? Because leases are the possession of use, the right to use or possess a certain product, not a full flat-out purchase or a good. Remember, I said Article 2 and Article 2A, they are companion. When we talk about sale of goods, we're also talking about leases of goods, and that I would alert you when leases doesn't apply. This is an opportunity or situation in which we're not talking about leases, but merely the sale of goods when we talk about title. Now, warranty of title arises automatically in most sales contracts. Warranty of title, there are three types of warranty of titles that arise automatically. We have good title, we have no liens, and we have no infringements. Okay? So, when you have good title, a seller warrants that he or she has valid title to the goods sold, and that transfer of the title is rightful. So if we look at our sample of our New York State title for a vehicle, this is what a title will look like. What happens if a buyer later finds out that the seller did not have good title? We have some problems. Alexis steals a diamond ring from Calvin and sells it to Emma, who does not know the ring was stolen. If Calvin discovers that Emma has the ring, can he reclaim it? Yes, we talked about that when we were talking about passage of title under the risk of loss section. Okay? Yes. Kelvin can recover. Now, what if, actually I'm going to back up. So Emma can recover. When Alexis sold Emma the ring, Alexis automatically warranted to Emma that the title conveyed was valid and that its transfer was rightful. Okay? Because a thief, as we discussed, has no title to stolen goods, what Alexis did in this situation was breach the warranty of title imposed by the UCC and becomes liable to Emma for appropriate damages. So Kelvin can reclaim his ring from Emma, but Emma has recourse as well. Okay? She can claim that Alexis breached the warranty of title and can sue under that for appropriate damages. So we talked about the seller warrants that title is good when they have valid title and that they have the right to transfer the title. They also warrant that there are no liens on the goods. What's a lien? A lien is an encumbrance on a property to satisfy or protect a claim for payment of a debt. An example of this would be a security interest from a creditor. Under this rule, the UCC protects buyers who are unaware of any liens against goods at the time of the contract was made. That means the buyer has to be unaware. It protects a buyer who unknowingly buys goods that are subject to a creditor's security interest. So if a creditor repossessed the goods from a buyer who had no knowledge of the security interest, then the buyer can recover from the seller for breach of warranty. And yes, the creditor can repossess the vehicle from the buyer. The buyer's recourse is that they have to sue for breach of warranty against the seller. But what if the buyer is aware of the lien? Then the buyer has actually known of the security interest or the lien, so then they would not be able to recover against the seller for breach of warranty. And it will take the goods, quote unquote, subject to the lien. What does that mean? Does that mean they have to pay the debt? No, they don't have to pay the debt, but if the seller doesn't pay the debt, then they risk the vehicle getting taken away, and then they can't sue for breach of warranty. So that's the caveat there. What happens if a creditor with a security interest lien repossesses the goods from a buyer who had knowledge of the lien? We just talked about that. If the buyer has knowledge, then they take it subject to the lien. And speaking of liens, before I forget, the title that I had of the vehicle, that's part of the handout. If you look on that title, if you see in the bottom, if it's facing you, it'd be the bottom left-hand corner, Volkswagen Credit is the lien holder on this vehicle, which means, let me take you through this. If you were going to buy a vehicle from John Public, he would have to hand you the title to his vehicle. The vehicle would not have anything written in the bottom that says lien holder. It would be completely blank, and he would be able to transfer title to you. If you get handed this title from John Public and you see lien holder and you see Volkswagen Credit, then you know that there's some security interest in that vehicle that could ultimately subject it to repossession if there's certainly the outstanding loan. So when you see a title, if you're buying a car and you get handed a title that has a lien holder on the bottom, you make sure you get quote unquote clear title when you transfer the vehicle. But in this instance, in this example, if John sold his vehicle, it is subject to a security interest from Volkswagen Credit. And if the buyer is unknown of that and the car is repossessed, the buyer can sue John Public under a breach of warranty and to recollect the money that he paid. So what if the seller is a merchant and the buyer is a buyer in the ordinary course of business? We know what that is, right? The buyer in the ordinary course of business. We had that definition. The buyer will be free of the security interest even if he knows of it, which means he will have the right to sue the seller in either case, whether he knew that there was a lien on it or not, for a breach of warranty. So if the seller is a merchant and the buyer is a buyer in the ordinary course of business, and we've had that definition already in the past, buyer is free of the security interest even if he or she knows of it. But there is an exception where that buyer knows that the sale is in violation of the security interest. Then it will become subject to it. If you remember our example, Rick and his guitar from Risk of Loss. Rick has a rare and expensive electric guitar which he values highly. The story is that it was once played by Elvis, but it's on the blink. And I'm going to add a few facts to it. He bought it for $10,000 and makes payments on it to Credit Union. Credit Union has a security interest in the guitar until paid in full. Rick takes it in for repairs to Kathy's Music City, a retail store selling various musical instruments, which also has a service department. When he goes to pick it up, an embarrassed Kathy tells him that one of her clerks mistakenly sold it to Chris. Does Chris own the guitar? We talked about this. Yes, Chris owns the guitar. He does. Under the title had passed to him, despite the fact that Kathy didn't have title because of the entrustment rule, Kathy being a merchant. So Chris has good title. The question is, who owes the credit union? As of right now, Rick owes the credit union. What are Rick's options in this case? He's going to have to sue Kathy, right? He'll have to sue Kathy for his debt. Now, what if he stops paying? What if Rick stops paying the credit union? Can the credit union repossess the guitar? Yes. The credit union can repossess the guitar because there's a security interest on it. And if that happens, because Rick stops paying, because he doesn't have the guitar anymore, what's Chris's recourse? Chris can sue Kathy also for a breach of warranty. In either case, whether he knew about the security interest or not is one thing. But if the buyer knew that Kathy didn't have the right to sell it, didn't have good title or have that right, then he's going to take it subject. Chris is going to take it subject to the security interest. If that's a little confusing, listen through that again slowly to hear the breakdown of who can be liable when in that situation. And the last thing the seller warrants against is infringement of any patent, trademark, or copyright. We're not going to delve into that one. It doesn't come up often. The other two, warranty of title and the no liens, is the most important concept of these three. So the key to warranties of title is that title conveyed is good and that the goods are free of any encumbrances. Okay, no infringements, no liens, of which the buyer is unaware. And in that instance, if any of those things, if there is a lien, if there is an infringement, or if title wasn't good, the buyer will have and is unaware, the buyer will have the ability to sue for a breach of warranty. Can it be disclaimed? Can there be a disclaimer of title of warranty? Title of warranty can be disclaimed or modified, but it must have specific language in the contract. What do I mean by that? Example, Craft Tool Corporation sells metalworking tools to Dunlap Milling Company and other manufacturing firms. The disclaimer may be something like that it is only transferring the rights, title, and interest that it has in the goods. That may be a proper disclaimer for a warranty on the title. There are sometimes issues with or assurances to title that are obvious to the buyer. Christian, who's a resident of Clinton County, borrows funds to buy a car from Town Motors. He defaults on the payments. The car is repossessed, and under a court order obtained by Town Motors, the car is later sold at a public auction or a county auction to satisfy the debt. So Wade, who buys the car at this county auction, knows that it's not the property of the county official conducting the sale, right? That's obvious. So there's situations where there's no assurances as to title. That would be one situation relative to that. So there are more examples on this issue. You can check them out on the handout relative to the warranties. Express warranties. What's an express warranty? It's a promise that is included in an agreement under which the promisor assures the quality, description, and performance of the goods. So when does it arise? Three ways. When does it arise? That the goods conform to an affirmation or promise of fact that the seller makes to the buyer about the goods. For example, these drill bits will easily penetrate stainless steel. That would be an affirmation or a promise of fact, right? That's an affirmation. These drill bits that I'm selling you will easily penetrate stainless steel, and if that's what you're trying to do is penetrate stainless steel, you're going to buy them, right? So that's a affirmation of fact that the seller makes to the buyer about the goods. That the goods conform to any description. This crate contains one diesel engine, and you open up the crate and there's 5, or there isn't even a diesel engine, it's a different kind of engine. Number 3, that the goods conform to any sample or model. For example, Howard, a sports equipment salesperson, shows Joe sample baseballs. Joe orders 100 of them. The balls delivered must conform to those samples that the salesperson, Howard, was showing Joe. An express warranty is a material term of the sales contract. Okay? It's a material term. No formal words are needed to create it. They can be found in advertisements or brochures. So, this electric saw comes with a lifetime guarantee if you're reading an ad and you see it, right? It could be written in the contract. It could be a salesperson's oral promise. Example. Let's work through an example. Do I have it up on my sheet? Let's work through my example, and then we'll get to basis of the bargain. Buyer contracts to purchase a stated quality of number 2 milling wheat from the seller. That's what you know. Buyer contracts to purchase a stated quality of number 2 milling wheat from the seller. Is an express warranty part of this deal? And if so, for what? Yes, because it's automatic. Having an express warranty. But what are we warranting? We're warranting that what is delivered will be in fact number 2 milling wheat. What exactly is that? How do we determine what is covered by the given description? Well, something called wheat, I guess, right? But the test is reasonable person in buyer's position, buying in that particular market, would expect to be delivered when a contract is made under the description. So that's when you have something like that, it's kind of, I don't want to say it's kind of vague, but buyers contracting to purchase quality of number 2 milling wheat. That's all we know. It better be number 2 milling wheat that qualifies under a reasonable person in the buyer's position, buying in that particular market, and that it would be expected, the item would be expected to be delivered with the contract made under the description. There's that darn reasonable person. So Betty so the key here is what's their basis of the bargain? And we're going to talk about that when I talk about Betty in 1 second. I have to grab my example. Okay, so Betty. Betty goes to Carmen's used auto emporium where she sees a used car which appeals to her. It is marked 2002 Honda Civic on the windshield. She agrees to buy the car from Carmen, and the bill of sale states that the sale is of a 2002 Honda Civic. Betty drives off in the car, and based on each of the following additional facts that I'm going to give you, determine what express warranties, if any, Betty has gotten from Carmen. So the first one is there are no additional facts. Those are the facts. Is there an express warranty, and for what? Yes, there's an express warranty. And it's for what? A 2002 Honda Civic. And if that's all we know, then we're going to base it on, and if there's a problem, and we're going to base it on the test that I just gave you for the reasonable person in the buyer's position, buying in that particular market, would expect to be delivered when a contract is made under that description. So that's the first express warranty. How about this? Prior to entering into the sales agreement, Carmen told Betty it has power steering and power brakes. Do we have an express warranty? The answer is we do. Yes. Under what? Under which one of those? The first one, that the goods conform to an affirmation or promise of fact that the seller makes to the buyer about the goods. Carmen says, that's a fact. It has power steering and power brakes. So she drives off and she finds out it doesn't have either one of those or neither of those. There's a breach of an express warranty. When first examining the car, Betty looked at the odometer and saw that it read 131,257 miles. Does that create an express warranty? Yes, it does. It creates an express warranty that the car has been driven that number of miles and no more, at least where the odometer reading is written into the sales agreement or on the bill of sale. But the fact that you could see it right in the vehicle, and that might had given her rise, that's in the description, right? Give rise to her purchasing the vehicle. How about in the car's glove compartment, Betty found the various papers that had been issued to its original owner. Among these were a maintenance log, which indicated that the car had been regularly serviced. Does that create an express warranty? Is that would that constitute an affirmation of fact or a description of the goods? Maybe, maybe not. I mean, if the seller pulled them out and handed them to her and said, hey, look, it was regularly serviced, will it create an express warranty? If something goes wrong with one of the service issues? Probably not. Could be argued, but probably not an affirmation of fact unless the salesperson pulled it out and handed it to Betty and said, hey, look, it's been serviced this many times. You shouldn't have any problems. How about the car's windshield bore a sticker indicating that it had passed the state's mandatory safety and pollution control inspection for the current year? That would probably be part of the description. So yes, that would create an express warranty. The goods conform to any description. There's a sticker right on the vehicle that says that it passed the state's mandatory safety and pollution control inspection for that year, and something goes wrong or it doesn't pass within that year, there's probably going to be a breach of express warranty. So how about in my last example, in the course of negotiations, Carmen had said to her, this is the finest car I have ever had on my lot. Would that create an express warranty? Is that an affirmation or a promise of a fact? Betty might try and argue that, but I think that's going to be an opinion. made by the seller, and opinions do not constitute a express warranty. We'll talk more about opinions in a little bit, but in that case, that wouldn't create the express warranty. So there's no formal words. There's no formal words that are needed to create an express warranty, such as I warrant or I guarantee, or that the seller has the specific intention to make a warranty. She could just say it has. In that example, it has power steering. She may not realize that she's making a warranty when she says that, but it is. So you only need one of those three things, and it has to be for the basis of the bargain. Now here we are, basis of the bargain. What do I mean by basis of the bargain? What induces the buyer to enter in the contract, right? We don't have a definition for basis of the bargain, but it's determined on a case-by-case basis. And the test is whether a representation was made at such a time and in such a way that it induced the buyer to enter a contract. Oh, it has power steering and power brakes. Great, that's what I'm looking for. And then it doesn't. That's what induced Betty to buy the vehicle. So our opinions, back to Carmen and Betty. This is the finest vehicle I ever had on my lot. An opinion, right? Opinions. If the seller makes a statement that relates to a value or worth that's worth a fortune, or makes a statement of opinion or recommendation about the goods, these are not express warranties. These 3D TVs are excellent and unsurpassed. It's puffery, right? There's no, you can't affirm that one way or the other. Unlike the power steering, it comes with power steering. Okay, well we can confirm that. It does or it doesn't. With opinions or recommendations or comments regarding value or worth, those are not going to be express warranties. Remember we talked about value in making contracts. It's the value at the time that the contract's made. There is an exception. There's always exception to the rules, right? Vincent, the art dealer and expert in 17th century paintings, tells Lacey that a painting is a Rembrandt. She buys it. Later she learns it's not. Can she sue based on express warranty here? Yes, because Vincent has warranted the accuracy of his opinion. He is an expert, and if the seller is an expert and gives an opinion, as an expert, a warranty can be created. So if she bought this from, a 16-year-old who was filling in at the art gallery, and he says, yeah, I think this is a Rembrandt, or I'm told that this is a Rembrandt, that's not going to create the express warranty. But if an expert says so, then it will. Rudy is a salesperson for Miller Hardware. Rudy's salesperson makes a statement. Rudy makes a statement that a ladder will never break and will last a lifetime. Do these statements create an expressed warranty? Got a little typo there. No extra salesperson. So, does Rudy's statement, this ladder will never break and will last a lifetime, do these create statements? No, they don't. What do they create? Nothing. There's a rule relative to reasonableness, right? A buyer can't expect every single statement said to them to create an express warranty. So statements that are so improbable that no reasonable buyer should rely on them is not going to give rise to an express warranty. So you have to have some sort of buyer's reasonableness. The ladder will never break and it will last a lifetime. No one really believes that. They certainly want it to last longer than a week. But if you have it for 25 years, well, maybe it lasts a little bit longer than us. I don't know. But comments like that are not going to create an express warranty. So then we move on to implied warranties. Express warranties, they become part of the contract through some overt act by the seller. Okay? Implied warranties, there's some sort of inaction that's happening that creates the warranty. So it's a warranty that the law implies through either the situation of the parties or the nature of the transaction. And we have two types of implied warranties. We have an implied warranty of merchantability, and we have implied warranty of fitness for a particular purpose. First one we're going to talk about is the implied warranty of merchantability. And who does that apply to? The merchant. So it's a warranty by a merchant seller of goods that the goods are reasonably fit for the general purpose for which they are sold. So the key here is we're dealing with a merchant. This warranty arises in every sale of goods made by a merchant seller who deals in goods of that kind. So Mountaintop Sports, a retailer of sports gear, makes an implied warranty of merchantability when it sells a pair of skis to Rosanna, a consumer. But Damien, Rosanna's neighbor, does not make such a warranty when he sells his skis at a garage sale. Okay, so you have to have a seller who's a merchant to get the implied warranty of merchantability. So goods that are merchantable, what might be an example? So reasonably fit for the general purpose for which such goods are sold. What does it have to consist of? These are the things you have to look for. That, the goods are average, fair, or medium grade quality. A quality that is comparable to quality that will pass without objection in the trade of those in those goods. They're adequately packaged and labeled. They conform to promises of fact made on the labels. You will, I have a list on that handout sheet relative to warranties. You can kind of go through additional information. Examples of non-merchantable goods: light bulbs that explode when you switch them on, pajamas that burst into flames on slight contact with a stove, high heels that break under normal use. Okay, you get the if the goods are non-merchantable, regardless of the merchant's knowledge of defects, you still have the implied warranty of merchantability. The merchant does not need to know. Now I have some examples that are on that sheet that apply to this concept. There's two. You can read through those, see if you can figure them out based on the rules that I gave you in the handout, and then listen to the video. But I have some additional examples relative to the warranty of merchantability. So implied warranty of fitness for a particular purpose. What is that? It's a warranty that arises when a seller knows the particular purpose for which a buyer will use the goods and knows that the buyer is relying on his or her skill and judgment to select the suitable goods. So you need two things. It arises when the seller knows the particular purpose for which a buyer will use the goods and knows that the buyer is relying on that seller's skill and judgment when selecting suitable goods. Okay? So what's the difference? I'll ask you this. Who does this apply to? Everyone. You don't just have to be a merchant. This applies to everyone. So what's the difference between particular purpose of the buyer versus ordinary purpose for which goods are used? How do we know? How do these differ? Well, goods can be merchantable, i.e. ordinary purpose for which the goods are used, but unfit for a buyer's particular purpose, right? Buyer walks into a store and the sales clerk says, "This saw will cut through metal." The seller has created an express warranty. Buyer comes into a store and asks the sales clerk for a saw to cut through copper tubing, and the sales clerk refers the customer to a wall where there's different saws. It's reasonable for the buyer to assume that all the saws on the wall will satisfy the particular purpose that the buyer indicated. Thus, an implied warranty of fitness to a particular purpose. So Denzel needs a gallon of paint to match the color of his office walls. It's a light shade of peach. He takes a sample to the paint store and requests a gallon of paint that color. Instead, he's given a gallon of bright blue paint. Do we have a breach of warranty? Yes, we do. Which one? Do we have implied warranty of merchantability or fitness for a particular purpose. It's going to be a breach of an implied warranty of fitness for a particular purpose. Why? Well, the paint is merchantable, the paint's suitable, it's a suitable quality and for painting on walls, but it's not for Denzel's particular purpose. And I want to point out that the seller doesn't need to have actual knowledge of the buyer's purpose. They just have reason to know. So if you walk in and you say you need paint and you're painting in your house, they don't need to know what room, the size. They don't need to know. No. They just have to have reasonable knowledge, right? A reason to know. Lastly, we have some other warranties that are implied. They can arise out of course of dealing, trade usage, or course of performance. But the key here, the rule, is that in the absence of evidence to the contrary, when both parties to a contract have knowledge of a well-recognized trade custom, the courts will infer that they both intended that custom apply in their contract. For example, there's an industry-wide custom to lubricate a new car before it is delivered, and a dealer fails to do so. The dealer can be held liable to a buyer for damages resulting from a breach of implied warranty. So in that case, there's this custom that cars be lubricated before going to the dealer or being sold, and if it doesn't happen, then that's a breach of a warranty. Can warranties be disclaimed? They sure can. Depends on which one. How they're disclaimed will depend on which type of warranty we're dealing with. So an express warranty, they can be excluded or limited. And disclaimer, let's talk about the sellers. How can they disclaim their warranty? Well, first of all, they don't do any of the three things that creates the express warranty, like they don't make a promise or an affirmation of fact relating to the goods. They don't describe the goods in a way that they're not. And they don't use a sample or a model to represent the goods. That's one way. The other way, under the UCC, is by using specific and unambiguous wording in the written sales contract that eliminates any warranty. And the goal is that it protects the buyer from any surprises. That's the goal. Okay? Implied warranties. They can be excluded or limited. How? Generally, implied warranties of merchantability and implied warranties of fitness are disclaimed by expressions like as is, with all faults, and other similar expressions that would be common understanding to both parties. We see this, if you're selling something on Craigslist, we know that the fitness warranty applies to anybody who sells things. So when you're selling stuff on Craigslist, I hope you put as is or something of that nature. But specifically, a disclaimer for an implied warranty of fitness for a particular purpose must be in writing, and conspicuous. So the word fitness does not have to be mentioned in the writing. It is sufficient, for example, that the disclaimer said something like this. I give you an example here. There are no warranties that extend beyond the description on the face thereof. And it has to be in writing. It has to be obvious when we're dealing with a disclaimer of an implied warranty of fitness for a particular purpose. When we're dealing with a disclaimer of a warranty of merchantability, which only applies to merchants, must specifically use the word merchantability. You have to use it in some form. Oddly, it doesn't have to be in writing, but if it is, the writing must be conspicuous or obvious. So that's what you need to disclaim. The key to disclaimers, the point in disclaimers and is one, the sellers don't want to be responsible or warrant anything that's beyond what they have. But also, it's for the buyer's attention to the fact that there aren't going to be any warranties here. The buyer can't be surprised. What happens when if the buyer actually inspects the property or inspects the goods before entering into a contract? Do any warranties attach? If a buyer examines goods before entering the contract or refuses to inspect goods, there is no implied warranty with respect to defects that a reasonable examination would reveal. Okay? So failing to examine or refusing to examine, they're two different things. The refusal occurs when the seller demands inspection of the goods and the buyer declines. The seller will remain liable for any hidden defects that ordinary inspection would not reveal, depending on the buyer's skill and method of examination. So if Robin is an auto mechanic, he's buying a car, what would you expect from him? That he should be able to discover defects that a non-expert buyer would not expect to find. Like if he was buying a used vehicle and I was buying a used vehicle and something arises, if it's something that a reasonable buyer could detect upon examination, it's going to be based on the level of the experience of the buyer. Obviously, he would be able to detect more things in a vehicle than I would be able to detect. So he should be able to discover defects that a non-expert buyer would not be able to expect to find, and the circumstances determine what defects on inspection should be revealed. So what he would reasonably examine, what I would reasonably examine are two different things. But where a buyer examines goods before entering the contract or refuses to do so, there is no implied warranty relative to defects that a reasonable examination would reveal. And there's my rule and my example. Seller remains liable for hidden defects that an inspection would not reveal, depending on the buyer's skill and method of examination. And lastly, I don't want to spend tons of time on product liability, and I'm not. It's not under contract law. These negligence, misrepresentation, strict liability all fall under tort law. And I believe you had tort law, business law 1. So not only can you have a claim based on a breach of a warranty under one of those theories that we just talked about, there could be claims under tort law as well. Manufacturers and sellers can be held liable for physical harm and property damage caused by their products, and certainly under breach of warranties. And I will say that breach of warranties are the seller or the manufacturer is held strictly liable. And I'm going to start there and work my way backwards. The meaning of strict liability for purposes of this class. People are liable for the result of their acts, regardless of their intentions or their exercise of reasonable care. So if there's a breach of warranty, let's take the Betty and the Carmen issue, where the seller represents that the car has power steering and then doesn't have power steering, and Betty sues, maybe for the value of the car or wants to get out of the contract. You said it had power steering, it doesn't. This is the basis of the bargain. This is why I bought the car. There's nothing that Carmen can say or do, despite, oops, I didn't mean to say that. I didn't use the right degree of care when I said that, or that wasn't my intention when I said that. It's done. Once it's said, it's said. And if that was the basis of the bargain, Carmen's going to be held, what they say, strictly liable. Okay? So when you have breach of warranties and there's a breach of that warranty, they're strictly liable. That's also in cases of defects in products. Again, that would be something underneath tort law, and I could spend a whole entire half of the semester talking about strict liability and when manufacturers and sellers are. But you just need to know the definition of strict liability that I just gave you. And then, you can be sued for negligence, failure to use a degree of care that is reasonable, that a reasonable, prudent person would have used under the circumstances, negligence. And misrepresentation, we actually talked about this under common law, fraudulent misrepresentation. It exists here as well. Example, Bright Eyes Company makes and sells cosmetics. It intentionally mislabels packaged cosmetics or intentionally conceals a product's defect. They can be held by, they can be sued for fraudulent misrepresentation. And we discussed that under common law. So that wraps up warranties. That wraps up sales, a sale of goods. And you should be able to move on to the exam after you work through the practice questions to make sure you got them and listen to the 2 examples.